All right, let's get started. Good morning. Welcome, everyone. We have a session for you on fighting for and winning federal clemency and compassionate release. You just heard a wonderful discussion from the previous panel on the theory and policy behind clemency. Our emphasis is going to be on the practice. And we have a great group of panelists. They're all successful practitioners. I will speak now for a few minutes introducing the topic of federal clemency and federal compassionate release, and then our panelists will introduce themselves and tell you why or how they view the notion of second chance and basically why they do the work they do. So let me start out and talk about federal clemency. I'm going to try to be brief. Let's start with the different types of federal clemency. Clemency is something you don't study in law school. The press gets it wrong all the time, but there are basically three key types of clemency. There's commutation, which can reduce a sentence, even lead to release for somebody who is in federal prison. There's what's called a pardon after conviction, and a pardon after conviction does not erase the conviction. What it does is restore your rights, and you have to wait under Department of Justice rules 5 years in order to apply, and in that time show that you've successfully re-entered the community. Now, the word pardon also is ambiguous. There's the generic sense when we talk about the pardon power that covers all clemency. There's the specific sense of pardon after conviction. There's also something else, and we saw it in the last administration, and it's called a preemptive pardon. A preemptive pardon is when the president pardons somebody before their conviction is final, or even before the person has been prosecuted. And the best example would be Richard Nixon. He was pardoned, and so he avoided any conviction and simply resigned from office, and that was that. The story of clemency now is sort of a before and after, because this last administration with President Trump used preemptive pardons, used the pardon power in a way that was basically top down. I was the acting head of the pardon office for part of Trump's administration. My better days were as the deputy pardon attorney during the Clemency Initiative. That's how I came to the pardon attorney's office. I'm a career public defender. But I stayed on for a while, for as long as I could, under the Trump administration. And there you saw that what was going on was a top-down set of grants of clemency, as opposed to what had been the traditional protocol for decades before the Trump administration. And this is the after now, is with the Biden administration, the protocol has been reinstated. So we are now back to the traditional way that presidents get recommendations from the Department of Justice and then make decisions. So let's talk about how the traditional protocol works, because that's what's going to be working now. The traditional protocol, you go to the pardon attorney's website, you get an application, you put in an application to the pardon attorney's office. There, a line attorney evaluates your application and makes an initial decision of whether you're in the ballpark and it looks like you could be considered for a grant of clemency, or you are really not in the ballpark, and there's going to be a denial written very quickly, a denial recommendation. If you're in the ballpark, then what happens is, and I'm going to concentrate on commutation because that's really second chance. Pardons are important for fully re-entering the community, but here we're talking about fighting against mass incarceration, getting people released who deserve to be released. So in terms of commutations, what happens is, if you're considered in the ballpark, then there's a referral sent out to the U.S. attorney in the district of conviction for his or her opinion, and a referral sent out to the sentencing judge for his or her opinion. You get that back, and then the line attorney makes some final evaluation. Should this be a favorable recommendation or a recommendation for denial? It goes up to the pardon attorney. The pardon attorney reviews it, could flip the recommendation, could stay with the recommendation, but then it goes up to the deputy attorney general, because the way the protocol works is the attorney general has delegated the authority to decide the Department of Justice's position on clemency applications to the deputy attorney general, the person called the DAG. The DAG can then flip the recommendation from the pardon attorney or stay with it, and will then send it up as the recommendation of the Department of Justice to White House counsel. The White House counsel will review it. They will decide how they feel about it, and then send finally the recommendation on to the president, who will review it and make a decision. It would work perfectly if all this went smoothly and expeditiously. It doesn't. And one of the frustrating things about clemency is that oftentimes, instead of a denial, what you get is the application being stuck at a certain stage of the process. And for this reason, critics rightly say that there's an awful lot of levels of review that make it a very inefficient process. Now let's talk about the criteria. The criteria for commutation is actually part of the regulations that govern the Department of Justice, and also part of what is now called the Justice Manual, used to be called the United States Attorney's Manual. There's traditional criteria, and then for that period during the Obama administration, there were alternative criteria. So let me talk about the traditional criteria. The traditional criteria, the first one's very important. It's a disparity or undue severity in the sentence. This right here, we could just stop and take a look at so many sentences people are serving in the Federal Bureau of Prisons and start granting loads of commutations. But unfortunately, that hasn't happened. The only time there was anything like I won't call it mass, but quite a few commutations was during the clemency initiative under the Obama administration. The second criterion is critical illness or old age. The third is meritorious service to the government that's gone unrewarded. And then there's a catch-all that the office can consider other equitable factors, such as demonstrated rehabilitation and exigent circumstances that were not seen by the court at the time of sentencing. The unwritten part of the commutation criteria is twofold. One, if you're considered a danger to the public, you're not going to get a positive recommendation. And two, if you're not accepting responsibility, you have a huge hurdle in front of you to convince anybody that you should get a favorable recommendation. All right, now let me give you the real story. I've just found out, this information hasn't gone public, that finally the Biden administration has chosen a pardon attorney. Now this is very good news, because there's a very competent acting pardon attorney. She was my deputy attorney for the time, pardon attorney for the time I was in the office as the acting pardon attorney. But until the administration really says, okay, we're going to pick a pardon attorney, there's really no indication that the administration is going to do anything on clemency. And as we've heard, there haven't been any grants of clemency in the year that Biden has been in office. So this is a good sign, because number one, this means that now the administration and the Department of Justice might be turning attention to clemency. They haven't announced who the pardon attorney is, but there are certain screening procedures, and then it will be announced. And there's some hope that, and some hints previously from Biden administration officials, that there might be a new clemency initiative that this administration establishes that will lead, will introduce alternate criteria and lead to maybe more than the 1,700 commutations that were granted under President Obama. So that's the story with clemency. I think we all need to be gearing up for the idea that there may be a clemency initiative. But now let's go to compassionate release, because I will tell you, in my experience in the office, watching what's happened with the Department of Justice, clemency has not been available for people who have violence in their background, who committed violent crimes or engaged in violent behavior while in custody. And that's a real shortcoming, because without considering people who have changed their lives, who may have done something seriously violent years ago, but have transformed themselves, have redeemed themselves, they should be considered for clemency. I don't think that's going to happen very soon with the Department of Justice in control of the criteria. But there's compassionate release. And compassionate release, I think our panelists can tell you more about it, because I practice in the District of Columbia, and we have our own compassionate release statute, which is quite a bit better than the federal. And so I don't practice anymore under the federal statute. But the idea is this: there's another before and after. The First Step Act actually opened up compassionate release. Before that, it was almost impossible to get. The warden had to recommend the person to be considered for compassionate release. That was it. With the First Step Act, wonderfully so, it's now, if you exhaust administrative remedies, if the warden denies you or doesn't act for 30 days, you can make your motion directly to the court, and now you can get some action. And of course, you have to show you're not a danger, and you have to show an extraordinary and compelling reason. And there are certain enumerated categories, but the wonderful thing is that the extraordinary and compelling reason, or a combination of reasons, is not limited. And so, for example, as you've seen from the earlier panel, many people have been released on the basis of acute vulnerability to the COVID pandemic. And in DC, we've had many people released for that reason. So that's an extraordinary and compelling reason that's not in the statute, but can be used. And so you can search for other extraordinary and compelling reasons and make it work. And you can also take somebody who was convicted of murder, maybe 15, maybe 30 years ago. That person can be eligible for compassionate release. So there's hope there when you're talking about a second chance in federal criminal justice to use the compassionate release statute. Now, let me start with our panelists. Let me start with JaneAnne Murray. JaneAnne, if you could introduce yourself, tell the audience something about yourself, and tell us also why you believe in second chances or what it means to you, that would be great.
Thanks so much, Larry. So my name is JaneAnne Murray. I'm a professor at the University of Minnesota Law School, where I teach at Clemency Clinic, and I'm also involved with the National Association of Criminal Defense Lawyers, running its trial penalty clemency program. Thank you for inviting me to this terrific symposium. I got involved in clemency work back in 2014 when President Obama called on the bar to mobilize to represent individuals serving long sentences. In that process, I involved some of my students in representing some cases. And when I saw the interest that it garnered among them and how meaningful it was, we started doing more and more until it eventually became the clinic that it is now. Each semester, 6 to 8 students take on a case, whether federal, state, or compassionate release. They have their own client, they work on it, work it up to the point of filing it. And it is a way really of getting getting the future generation of lawyers to really think about the meaning of incarceration, the meaning of the sentences that they may well be seeking if they become prosecutors, and whether they become prosecutors themselves or talk to fellow students who become prosecutors. I think it's just an incremental way of getting that more humane approach out there to students. As I say, we did federal cases, we did state cases in New York, we now do state cases in Minnesota. You might have heard Mark Osler talk about that in the previous presentation. It does require a unanimous vote, so it's a lot harder to get clemency, but it is a fascinating, transparent, open proceeding, which is live streamed and in public, and people are able to see the impact of incarceration on individuals in prison, the impact on individuals who are now out of prison and 10, 20 years beyond their conviction, but the fact that it's still weighing on them and influencing their lives. What is second chance for me? Well, obviously people have been saying throughout this seminar, second chance is a chance for the impacted individual to get a second act, and for people incarcerated to rejoin the community, embrace their relationships and start anew outside the awfulness of prison. Second chance, I think, is more, in another way, and I know this may sound like it's not very much, but it's a chance for these individuals to have their story told again, better, maybe more humanely, more meaningfully, just maybe at all. Sometimes it's shocking for me to have gone back and looked at the sentencing transcript, seen people sent away for 30 years on a transcript that lasted 5 to 10 pages, where no sentence memo was written for them. So nobody told their story. And it has, I'm very struck in talking to my clients, how meaningful it is to have my students come in and take the time and the trouble to write up their story. And as they say to me, it gives me hope. I try to manage expectations and tell them what the statistics are. And, at the end of the day, they say, I don't care, JaneAnne, it gives me hope. And, there's a judge in the Sixth Circuit, and his name escapes me, I was trying to look it up, who said, without hope, there's only despair. And finally, second chance for me is really a second chance for us as members of the legal community and members of society to get a second chance to redress the ravages of mass incarceration that have been enacted in our names. And we bear responsibility. Our politicians went out there, took our votes and turned them into the law and order policies that have incarcerated so many. And second chance is a way for us really to come back and say to those individuals that we want a second chance at trying to get it right this time. Thank you.
Thank you, JaneAnne. How about you, Huma? Huma Rashid has joined our panel to our great benefit.
Hi, I'm Huma. I am a criminal defense. Well, I spent about 8 years being a criminal defense attorney in Chicago, and I practiced kind of evenly in Illinois, as well as a bunch of the Midwestern states on the federal level. And for the past 2 years, I have been with the Aleph Institute, which is a national nonprofit. And it's led by, I like to call them a small army of rabbis. It's a wonderful organization that, while they primarily minister to Jewish incarcerated people, they help anyone that comes to them. And I remember being a baby attorney and having a Jewish client that needed kosher food for Passover and, and all the other things he wanted. And Aleph jumped right in to help. And I'm honored to be able to work with them now as a clemency lawyer and as a mitigation specialist. And occupying both roles, I do a lot of compassionate release. And I started doing clemency under the Trump administration for Aleph in November of 2020. And we were very uniquely situated. We were able to get so many petitions and together and advocate for them. And so it was just an absolutely life-changing, part of my career, defining, stage of my career, and just launched me further into this space that I'm honored to be in and to share in with all these other excellent practitioners that we've seen over this 2-day symposium. As far as what second chances brings up for me, those of us, we've been we're in this 2-day symposium. We've had a chance to listen to so many great attorneys and other activists and affected people who were formerly incarcerated speak about their experience and the work they do. For everyone we saw speak, there are thousands more in this space. Family members, other attorneys, other activists, other nonprofits who are working diligently and have been for years, some of them their entire careers, on this. Everyone is inundated with requests for help. Everyone is, scrambling to get back to as many people as we can who reach out for us to help. And we're all second chance practitioners. And to me, that is a huge legislative, judicial, executive failure. It's a failure on every level. There should not be this many of us. There should not be this level of burden. There should not be this many people asking for help with this. And it's a failure on so many different levels. We're honored to do this work, of course, to take up that mantle to help people earn clemency. Because again, we don't earn it for them. We don't win it for them. We tell their story the best way we know how with our training, and we advance their cause. They're the ones who earn it. We are honored to do this work, but I wish there weren't as many of us. I'd be very happy if there wasn't a need for what we did.
Thank you, Huma. Our next panelist is Shon Hopwood, and I hope, Shon, you're going to admit to playing a critical role in the First Step Act, which is the most important criminal reform legislation in about 4 decades.
I did no such thing, Larry. My name's Shon Hopwood. I'll give you the traditional introduction that I give at most events. My name's Shon Hopwood. I'm an associate professor of law at Georgetown University Law Center, and I committed a violent crime, but I'm not a violent criminal. And I start with that because most people know my story up front, that I served nearly 11 years in federal prison for my role in 5 armed bank robberies when I was in my 20s. And now I'm a practicing lawyer and a law professor at Georgetown. But I also, it's my way of getting people to think about second chances from the opening sentence of me speaking, and getting people to realize that, just because someone commits a crime does not mean they are a criminal forever. And we too often link criminality and character traits together when those aren't necessarily compatible. And so I do work on both federal clemency and compassionate release, and did a lot of work with the Trump administration on the First Step Act. Was fortunate to be there the day that bill was signed by the president. And what I tell people is the First Step Act's 2 things at once. It's incredibly modest reform on the one hand. It doesn't even fix all of the problems in the federal criminal justice system and has no applicability to the 50 state systems in the country. On the other hand, it's the best reform bill to come out of Congress in my lifetime, which tells you how low the bar has been set by Congress for the last 40 years. And so, I've done a lot of work and was fortunate. I work with places like Aleph on clemencies with the Trump administration. I'm on the board and work with FAM, and I work with a lot of the other criminal justice reform organizations. But after, working on that clemency piece, I'll tell you, the last 3 years of my life has been spent on compassionate release, writing legal scholarship about it, litigating cases across the country. Just last weekend, I had the pleasure of going out to Las Vegas for a friend of mine's wedding. And this was a man that was serving a 213-year federal prison sentence for 9 robberies of massage parlors around Philadelphia when he was 23 years old, and he had served 20 years, and he was one of our first compassionate release wins. And so when Larry talks about, we need compassionate release because it's very difficult to get relief for people who committed violent felonies through clemency, that is true. And it's one of the reasons why I advocate every system needs overlapping remedies, in that you want a judge to be able to grant compassionate release. You want a parole board to be able to reward everyone who's rehabilitated. And then you want a functioning clemency process for those difficult cases that the other 2 bodies and decision makers haven't reached. And you want that because the political process makes it very difficult for presidents to grant clemency to people with certain crimes. And so that's the work I do. And I'm really honored to be here with such a great group of panelists and people that have come before us and that will come after us. And thank you.
Thanks so much, Shon. And now we have Len Goodman, who is a well-known and very experienced practitioner. Len, tell us about yourself.
Thank you, Larry. Yeah, my name is Len Goodman. I'm a criminal defense attorney here in Chicago. I practice about half trial work, half appellate work, habeas corpus, post-conviction, and about half federal and half state. So I'm sort of all over the place. Unlike my fellow panelists, I've had very little success on clemencies, federal clemencies for sure, a little more in the state system. In fact, I think my batting average would be close to zero if it were not for the fact that I had one client who went on a reality TV show hosted by a man who later became the president. So what I would like to say, I think I'd like to follow up on what JaneAnne and Huma said about, who's in prison and how much need there is to give people a second chance. And I would say there's, most federal prisoners, I think most people aren't even aware of this, and most federal prisoners are poor and nonviolent. About half are serving draconian drug sentences with no possibility of parole as a result of our misguided war on drugs that was launched in the 1980s. And I looked at the numbers this morning. There's, in 1980, there were 25,000 people in federal prison. Today, there's 150,000. So that's a 600% increase. Federal clemency is an important tool for many prisoners, but it's not enough. And we need major reforms, as others have talked about. We need to end mandatory minimums. We need to legalize marijuana. In the federal system, a lot of people don't realize it's still classified the same as heroin in the federal system. We need to bring back parole. And federal prisoners need to have a way to earn their way back home. So that's all I have to say. Thank you.
Thanks so much, Len. Let me just add to that. The history of clemency going back to the 19th century, presidents granted 50% of applications. And that more or less came to an end when the federal parole system was established sometime around the second decade of the 20th century. So in 1984, when the so-called Sentencing Reform Act, and the use of the word reform there is really very questionable, eliminated parole, that should have been the time when all of a sudden clemency reestablished itself as a vehicle for fairness and mercy, but it never did. Instead, we got mass incarceration. So I'll just say the reason second chances are so important to me is because I want to see people who have redeemed themselves earn what they deserve, which is release from prison and reentry into the community, where they can help the community, help the youth in the community, and live their lives as they should. So that's my take on second chances. And I'll tell you, I'm fortunate to be practicing in DC, where we have IRA, which is a second chance, a second look law for anybody who committed their offense prior to the age of 25. I wish it was with no limitation, but it is. But we have that, and we also have a pretty good compassionate release statute. Now, let me go to Huma and ask you, what are the nuts and bolts of filing a clemency petition? What do people need to gather to present the best petition?
Sure. So I had been in the unique position of practicing as, my other panelists in the wild, wild west days of Trump versus back to Biden, where it's a bit more by the book, for better or for worse. That's just, it is the system that it is that we're working in. But the themes remain the same. So under Trump, I was machine gunning as many clemency motions as I could. I had a very dedicated staff that was in charge of putting all the documents together and really just getting it all over as quickly as we could. Now under Biden, we have a bit more time to really explore different things, to take our time putting together the different documentation we need, and the materials remain pretty similar. So you will always need, if you're for for compassionate release especially, but also for clemency. If there are medical records, you want those. You want a complete picture of the person, and that often includes health issues, especially because we're in a global pandemic, and also because unfortunately life expectancy is greatly reduced in prison for many reasons. For the chronic, everything from the chronic stress that incarcerated people live under every moment of every day to, the unfortunately in a lot of facilities, the substandard medical care, which I know that there's a lot of good work being done nationwide in departments of corrections and prisons to increase that, but that's just where it is. We also need disciplinary records, because there's a big difference, unfortunately, between an incarcerated person who goes in and keeps their head down, has no tickets, no write-ups, which is a huge feat, unfortunately, too many places in the federal system, and a person who unfortunately has many write-ups. A common problem that is seen in that area is that a lot of people, when they first enter prison, it's such a traumatic experience that I can't even imagine how we cope with it. They might act up in the beginning, and unfortunately, 2, 3, 10, 15 years later, when they're up for clemency and trying to get that, it still haunts them because they're part of that record. We also love to get letters of support. And that's from all broad ranges of the community. Obviously, I want one from mom saying how good her boy is, and how he always would come over and take out the trash when she and dad were on break. Sure, we want that. We also want letters from employers, if that's available. Think about this. For many of my clemency clients who I was helping with their petitions, these were people who were in on life sentences, and that had not changed. They may have gotten a small reduction, with the changes in the law, but they were still in there for decades. And yet they still managed to send out letters, maintain contact with people in the community, such that an employer on the outside was willing to say, yeah, this person that's in for life, and we don't have anything yet saying otherwise, I am happy to give them a job. Like, think of the tenacity, the heart, the dedication, the determination, and of course, the rehabilitation and transformation that it takes to even secure something like that. And so it comes down primarily to disciplinary records as far as supporting materials, medical records as applicable, letters of support. If we can get them from prison counselors, those are the best. And unfortunately, they're a little harder to come by. But if we can get someone in, the prison education system or the work program, Unicor, who can say that this person showed up for work every day and they're a joy to be around. And, that really, it goes a very long way. Another letter of support that is very valuable and sometimes difficult to get is a letter of support from the trial prosecutor or the United States attorney or acting United States attorney for the district in which the person was sentenced. Obviously, they're prosecutors, their words carry a little more weight. So we are always very happy to get all the letters we can, from childhood best friends and spouses and kids, but also people who occupy high, roles of respect and esteem in the community.
Great. Len, tell us what you see as the challenges involved in filing a clemency petition and how you overcome these challenges.
Most, if not all, of the federal clemency petitions that I have filed have been on behalf of clients that went to trial, asserted their innocence, had strong claims of innocence, filed appeals, cert petitions, 2255s, which is the federal version of a habeas petition. And when you say, and Larry knows this much better than myself, but when you say I'm innocent, I was treated unfairly, prosecutors often dig in to justify their work in the case. So I think what I'd like to do is maybe give you two examples of cases that I've handled. I represented a man named Yuka. This was a case I handled at trial many years ago. I was a young attorney. He grew up in Inglewood. He was convicted by a jury on 2 out of 3 counts of federal drug conspiracy in the Southern District of Iowa. He was sentenced to life in prison. It was a nasty trial. The prosecution brought in 13 cooperators who all were offered leniency to say that Yuka was selling them drugs. A key defense witness became unavailable after the prosecutor threatened to take her kids away from her if she cooperated with the defense. It was shocking to me as a young attorney. We got one dissent on the 8th Circuit, Pyrrhic victory. One judge would have reversed for prosecutorial misconduct. We filed a 2255 later on after several witnesses recanted their trial testimony. We filed 2 cert petitions. Yuka filed for clemency under Obama as part of that initiative that you've heard about. He had a stellar record in prison. When we did everything that Huma has talked about, we got his, he had zero disciplinary reports in more than 15 years. He was an educator, so we had all the certificates. He helped hundreds of people get their GEDs. He ran the chess club. He ran the reentry program. Had an advocacy group supported Yuka. I wrote letters to the trial judge, the White House counsel, and the pardon attorney. I called the prosecutor on the phone and begged him to support the petition. He refused, and clemency was denied. So there's a happy ending. We did finally get Yuka out on a 2241 habeas petition based on some defect in his priors. And also thanks to a wonderful judge that we got before in the Southern District of Illinois, Judge Yandel, and the help of a great federal defender named Angela Hill. So Yuka's home and he's doing wonderful, and he got his second chance. The second case I would tell you about is Blagojevich, the former governor. There are many similarities to Yuka's case. He had 2 hard-fought trials, very nasty, long sentence that many believed was unjust, claims of innocence, claims of prosecutorial overreach, 2 Seventh Circuit appeals, 2 cert petitions. He also had a stellar prison record. He was a teacher. He had over 100 fellow inmates that wrote letters in support of his release, but the DOJ opposed. Fortunately for Rod, he knew the president. He knew President Trump. He had done an episode of Celebrity Apprentice while Rod was on bond awaiting trial. And he got along well with the president. The president had met the family and the girls, liked them, felt that there was an injustice. But even with that advantage, Rod still probably would not have been released because the DOJ was so opposed to his petition. What saved him was that President Trump had very little respect for the system, and Larry can talk about that, but he had very little respect for the regular process. And so he was able to go around the strong objections of the Department of Justice. So I guess, that's been my experience and my struggles, as a trial attorney. I sort of have unique challenges in the petitions that I filed, but and a very low success rate.
Thank you, Len. Let me ask JaneAnne and Shon. I'd want to hear you on this too. What tips would you have for navigating the politics of the federal clemency system?
I'm glad, Larry, that you asked the question in the sense of the politics of the clemency process, because it is inherently so political. And in our previous seminar section of this symposium, we were hearing about just how political and essentially arbitrary it is. In fact, I love the anecdote about President Lincoln walking around with a dedicated sort of pardon lieutenant who would write down the names of all the people that Abraham Lincoln was pardoning as he went along, and the grieving parents coming to him begging him to give clemency to their children who had deserted. So it's completely arbitrary who got their access to President Lincoln in that moment, and we've seen it over the years. The same issue of the access sort of determining the access to the president, determining your capacity to get clemency. And even under President Obama, when there was an effort to establish factors and create some uniformity and procedural fairness to it, nonetheless, there were politics involved in those factors themselves. So nonviolent, what is nonviolent? And so as an advocate, you are trying to work within those factors, but you're dealing with the deck of cards that you've got, and you've really got to put the best possible spin on this so that you can meet those factors with the arguments you're making. One of the things that I felt was successful in the past, and I've seen it over the years, is look, first of all, you've got to be completely transparent about all the negatives in your case, and you've got to know them, you've got to own them, and you've got to have a response to them. Secondly, well worth sending, once you've prepared that hopefully comprehensive petition preempting all the negatives and having all your arguments, consider previewing that with your prosecutor, or consider previewing it with the sentencing judge. The thing about the politics is that the politicians are terrified of being held responsible. They do not want that person who got out and did the terrible act, and then it's like, look, the president was the one who released that person into the community. So they want a cushion, they want backup, they want to be able to say the sentencing judge recommended it, the prosecutor recommended it. So playing the politics of this is trying to get multiple actors on board with your petition. People have used the media effectively. I'm very leery of that, but there are ways in which the media can be used. Perhaps your local senator could champion the cause of your client. So there are ways of, many ways of doing it, but at the end of the day, the most important thing is creating the most compelling petition you can, which means knowing all the facts and addressing all of them in the best way you can effectively as an advocate.
Thank you. And I want to make sure we have enough time to talk about compassionate release. So let me turn to Shon on this. Shon, how is compassionate release being used as a second look for long sentences? How can practitioners maximize this tool? And how can practitioners use clemency and compassionate release together?
Well, I think, again, you always want to give your client every opportunity at success. And so if you think they're both eligible for clemency and compassionate release, you would want to do that. There are some cases in which you have a judge for compassionate release that, no matter what your client's going through, no matter how excellent of a rehabilitation record your client has, that judge is just never going to reconsider the sentence. And so you'd want to file clemency too in case President Biden does something. But on the broader question, it used to be that the compassionate release was governed by the criteria and the sentencing guidelines, but 10 out of the 11 or 11 out of the 12 circuits now have said that policy statement is no longer applicable. The one that didn't happen to be a case that I argued in the 11th circuit, unfortunately. So I was on the wrong end of that 11-1 circuit split. But now there is no real criteria, and district court judges have full discretion, unbridled discretion, to find anything as extraordinary and compelling. And, I've been kind of going on a public education tour with federal judges across the country and explaining to them things like a prison record. I think most judges that I'm standing before would recognize that, I have gone through some pretty profound changes, and I, at least on outward appearances, look rehabilitated. Have to ask my wife and kids about that. But I tell them, I got 3 incident reports in 11 years. And does that mean that I wasn't deserving of getting out? Does that mean you would be concerned about me recidivating? No. And so, I tell them that a guard can have a bad day and show up to the prison and write you up for anything. I've seen it happen. And so therefore you shouldn't place, obviously if somebody has recent violence in their prison record, that's going to be hard to overcome. But all of these minor infractions should not be barring people from getting relief, whether it's clemency, compassionate release, or any other remedy. And so, I think anytime as an advocate, you want to pursue every potential option you can. We've had cases where we've pursued clemency, compassionate release, and a habeas petition all at the same time. And I just think you want to use every avenue you can. And fortunately now, at least for people who haven't committed violence or sex offenses or some of the other excludable offenses, there is this new earned time provision in federal prison, which is going to allow people to take programming and actually earn their release. Public policy wise, that's a great way of doing things. Not everyone in prison has the motivation to get up every day, particularly if they have a long sentence and kind of seize the day. And so you want to have incentives for people to do the right things. And I think clemency and compassionate release have already incentivized a whole lot of people in federal prison to start programming and start following the rules. And that's why I tell members of the federal government, you should be supportive of this, because ultimately it's going to reduce recidivism.
John, let me follow up with you. And ask you about two things. One is as a result of the First Step Act, the Department of Justice and Bureau of Prisons developed a risk assessment tool known as Pattern, and it gives you a score from minimal risk all the way up to high risk for general recidivism and for violent recidivism. How do you deal with that in doing a compassionate release motion?
Well, it depends on obviously what the score is. But what I say is even the risk assessment tool, we're just not great at predicting risk. If COVID has taught us anything, the entire country is horrible at predicting risk. And it's even worse in the criminal justice system, where we try to reduce risk to zero before we let somebody out for early release. And that's not really how we should look at it. And so, I try to contextualize that and say, Pattern may say this person is high risk, but look, they've done 100 different programs in prison in the last 10 years, and they've compiled a remarkable record of rehabilitation. And that's kind of what we did in Adam Clausen's case, my friend, to the point where once the judge said that he had extraordinary and compelling circumstances, a pretty remarkable thing happened. The assistant U.S. attorney named Bob Zausmer, who was a former pardon attorney, had remembered reading Adam's clemency petition. And during the hearing, he told the judge, listen, we don't think you have the authority to grant this, but now that you've made that decision, we're not going to relitigate it. As to the question of how much to reduce the sentence by, we, the government, agree with Mr. Hopwood that it should be time served. And oh, Judge, by the way, whatever you decide today will be the final decision because the government will not appeal. That just doesn't happen ever. But, I think with people that have really remarkable records of rehabilitation, regardless of their crimes, regardless of the pattern score, we got through to that judge, and the judge saw Adam for who he was, which is not some pattern score. And he's now out doing reentry work quite successfully in the city of Las Vegas. And so, I think you have to contextualize your client's record and explain that those risk assessment tools are not who those people are.
Okay. And a shout out to Bob Zausmer. He was my second boss. He was the pardon attorney after Deborah left, who was also wonderful. But Bob was a full-on prosecutor, career prosecutor, but he came in there and he made a good part of the Clemency Initiative work with his hard work and with his view of people earning redemption and deserving clemency.
We need more Bobs in the world.
Yep, we certainly do. One other question that I think your experience would give us some view of is when your client gets it's a 100 level infraction in the Bureau of Prisons, which is the most serious. It's possession of a weapon, and usually it's a shank. What do you do with that?
I think, again, you contextualize it. Did it happen 2 years before you're asking for early release? Or did it happen 10 years? Did it happen when that person was serving time at a U.S. penitentiary, a maximum security prison, where honestly, that's the price of staying alive in some places? Or was it at a camp where you would think that wouldn't really happen very often? So I think you have to contextualize what your client did and the circumstances they're under. I mean, if they're at a U.S. penitentiary, yes, they're not supposed to have that. But I think you tell the judge, listen, if you were surrounded by people who were trying to kill you, what would you do in this person's circumstances? You would try to defend yourself, and that's what this was, and that you shouldn't hold it against this person because the Bureau of Prisons failed them. And I would put it on the BOP, because oftentimes the Bureau of Prisons fails everybody that's on the inside. And that's why people resort to violence to protect themselves. It's not because anybody wants to go to prison and pick up a shank and continue with a gladiator school while they're serving their time. I know of very few people that want to do that.
Exactly.
On the disciplinary record, it can be such a significant factor in terms of a decision maker just saying, no, I don't want to touch this. So it's important to really map the violations and map them in connection with the individual's movements, because I've seen that sometimes very early in the movement to a new prison, you're going to see issues arise. They will get fighting shots, but you can get a fighting shot because if you defend yourself, if you're attacked and you defend yourself, you're going to get a fighting shot. Both of you get a fighting shot. The other person may be moved, but you won't. So, if you analyze this, you'll be able to show, look, this was the victim in an aggressive attack. So they ended up getting the fighting shot, but at the end of the day, they weren't the aggressor. There's many ways to mitigate the disciplinary record, and there are experts out there who are willing to give their time pro bono to review it. And it is a critical component to undermine, to preempt the negatives when you're presenting your petition.
When someone first is sentenced and they have a long sentence, that's when they're most likely to get disciplinary write-ups. I mean, as I tell judges, can you imagine being 20 years old and facing 20 years in prison? You're not going to initially reform immediately. I was a knucklehead the first 3 years I was in the prison system. I didn't learn my lesson, and it was only after a come to Jesus moment that I transitioned away from that. And I would hate to think that I would have been denied early release because of something that happened in the first year or two that I entered the system.
Right. Huma?
Sometimes the write-ups that they might have might be mitigating on their own. So it's really important to dig into, hey, I see that you had some contraband in your cell. Can you tell me about that? One of my clients, the contraband turned out to be a cup of soup that she wasn't technically allowed to have because her cellmate was sick. So yeah, I'm going to make a big deal of that in my petition because it shows what a sweetheart she is.
And I can't tell you how many times I use the terms evolution, transformation. There's an evolution of behavior from that early coming to a prison when you're adjusting, you've got all kinds of threats and dangers. You might have a weapon to protect yourself, but you haven't assaulted anybody. You haven't used the weapon proactively. You've just had the weapon for protection. And then there's an evolution where you learn how to avoid dangers. At least they persist, but at least you get better at avoiding infractions. And you see that with the inmates as they mature and accommodate to what are terrible conditions, of course. JaneAnne, tell us about what about a second look statute for the federal criminal justice system. What would that do, and what are the chances here?
Senator Cory Booker has a second look statute that's pending, which is a wonderful statute that's giving a second look, I believe, to everybody on a blanket basis after 10 years. Seriously, and it's the other wonderful aspects of it are, the person gets representation. So there will be appointed counsel for the individual. As I say, no exclusions, I believe, in terms of the crimes that will be applicable. The second look can go below a mandatory minimum. And in fact, the Bureau of Prisons will be charged with identifying petitioners. It's petitioner driven. It's not prosecutor driven. So it will all be an adversarial proceeding before a judge. So it's a terrific bill. Realistically, in today's law and order times, I think the prospects of this really getting off the ground are slim. This is not a great climate. It sometimes feels like we're back in the 90s again, and it's, hopefully things will ease, but there's an air, law and order issues are salient, plus there's a lot of economic insecurity. These are not a good backdrop for criminal justice reform, which is why the First Step Act was really so extraordinary, that we were able to get that. And it's been an extraordinary statute in terms of the numbers released through it, either through compassionate release, through retroactivity of the FSA, et cetera, and going forward, making it harder for prosecutors to give much more draconian sentences. Sorry, there was a follow-up to your question, I think, that I just wanted to add one thing, which I thought was great, that Shon mentioned, that he was going on an education tour with the judges. And I do think that what's happening with the compassionate release litigation, which is huge, and federal defenders have been fantastic in taking up that cudgel and putting thousands of cases through the system. What it has done is it's really educated judges on what's happening at the back end. You know, as a public defender, my clients used to go away and I wouldn't think about what their lives were going to be after the fact. I don't think the judges really think so clearly about it. Now they're getting fully fleshed out stories of these individuals, much more so than in Drugs Minus Two, which was a sort of a mechanical thing. And so they're really being forced to see, oh my goodness, these people, they've changed, they've reformed, they've got families that love them, that care about them, that have sending all these letters of support. They're suffering these horrible illnesses. They're getting terrible medical treatment for horrible illnesses. I mean, I'm hoping that it is really educating our judiciary in a way that really creates the climate for a second look. Second look's never going to pass unless the judges themselves say, you know what, we're open to it, because they're going to be the gatekeepers for that. And they're the ones who are going to have to deal with that onslaught of second look applications, which will be coming on a rolling basis every year once we pass something in that form. And so anyway, so I think that compassionate release litigation is a great opener for this kind of relief. Yeah.
Thank you. Forgive me for the number of times that I've thought in the 20 years of doing cases in front of federal judges and DC Superior Court judges, where I thought, if the judge could spend 3 days in a high security penitentiary in the Bureau of Prisons, we'd be in a different spot. I'm sorry, I can't put that out of my mind, but I don't think the judges would take me up on that request. Let's talk about, we get into a little policy. Well, before we do that, how about some more nuts and bolts on a compassionate release motion? Who wants to address that?
It's just a motion explaining usually why this person has extraordinary and compelling circumstances. You're usually pulling together cases that other circumstances and other cases where judges have granted relief to try and convince your judge that, listen, we're not asking you to go out on a limb here for this person. And then, you know, in most circuits, the judges have the power to do that. And then you have to re-argue the sentencing factors under 18 USC 3553A and explain why granting this person early release is compatible with the goals of sentencing. I'd also tell you, having a release plan where someone will file an affidavit saying this person's going to live with me, this person is going to hire the person who would be released early, goes a long ways towards convincing judges that someone has a plan for when they get out. And that's really the nuts. It's one filing. There's usually a response from the government, almost always opposing. I think during the 18 months at the height of the pandemic, the government received 33,000 requests for compassionate release. They acquiesced to 33 of those. Yes, you heard that right, 33. Mm-hmm. And so the government responds, you file a reply. In most cases, even in cases that are granted, the judges don't have hearings. Some judges do have hearings and want to know why they should do this, but many other judges will not. And generally, there's no right to counsel and no right for the person in prison to be present for those hearings. And so, it's pretty standard litigation, but it requires, again, you, much like the other panelists said, to retell this person's story and explain why they're not just a number, a inmate number, and tell their story and convince the judge why they're worthy of being released.
And there seems to be really such a structural similarity between a compassionate release motion, a clemency motion, or even the second look motions I file in DC. I mean, we're talking about, one, you got to show your client's not a danger. Two, you got to show rehabilitation, or what in some cases I like to call habilitation, because the person really is developing for the first time by the programming in custody into somebody who has marketable skills and who is a thoughtful, insightful person. And then the reentry plan. I don't think you can overemphasize the reentry plan, because that's that's part of convincing the judge that this person is going to make it in the community. There's a circle of support. There's a circle of people who are going to give emotional guidance, who are going to give all kinds of reentry support. And there are organizations that this person's going to work with. In DC, we have what's called the Free Mind Book Club. And they are a very active organization to take on returning citizens. We also have an organization within the city government for returning citizens. So all these things have to be hooked up, but it's basically very similar, whether it's clemency, compassionate release, or whether it's a second look.
I was just going to add one thing, Larry. So the Compassionate Release Clearinghouse, which is run by NACDL and FAM, is so fabulous. The resources there are amazing, wonderful people that Beth Blackwood and Shauna Rifkin, I believe she was in the previous symposium. The great people to give resources and advice. One of the things is the different circuits have different, the rules are different. You know, the circuits will accept different arguments. So you're in the Second Circuit, you can make an excessive sentence argument. You're in the Eighth Circuit, you can make that argument, but you're getting nowhere unless you've got a medical hook. Keep in mind that medical hook doesn't have to necessarily be physical. You could also have a mental illness issue. I'm working right now on a PTSD issue where my client had massive PTSD from things that happened in his childhood, and the lockdown and the experience of the COVID lockdown, which isn't looking like it's easing anytime soon, has really triggered it and exacerbated it. And there was a great case from the Second Circuit on PTSD being a factor that could be taken into account in compassionate release. So there are very creative ways of trying to get a medical argument in there, along with all your other great arguments, which may move the judge. But in your particular district, it may be really important that you have a medical argument before you have any opportunity of success.
How many of our clients have basically what is PTSD undiagnosed from a childhood in which they saw friends being murdered, in which they saw family members going to prison, in which they experienced beatings or abuse? How many with undiagnosed PTSD and unrecognized and unappreciated by the judges? The number to me is astounding.
Yes.
Let's talk about each of you. I want you to give me one suggestion for reform, either of clemency or of compassionate release, starting with Huma.
Oh man, I'm a broken record on this point. Categorical clemency. Let's create guidelines and expand them for different areas. You know, we had great success with first-time nonviolent offenders, but like Professor Murray said, what does nonviolent mean? That's something that practitioners have to kind of grapple with and scramble to put down. No, and that make it, you know, just expand all sorts of criteria that we have and get BOP in on the process, like we've been seeing, and just machine gun it, you know, just as broad as we can and go from there. In the sky.
One thing we can hold BOP to, they have this risk assessment tool that we've talked about, and there's all kinds of problems with aggregate risk assessment tools. But if somebody scores minimum on that risk assessment tool, BOP should be recommending that they be released. And so you could have a categorical clemency based on that, you know, certain number of years served, a minimum recidivism risk. Let's go. Get it out.
And it works against us half the time with the percent of the sentence served and, you know, percent left, but I want it to work for us. If there's a certain portion left, pick an arbitrary number. Is a person really going to be more rehabilitated if they serve an extra year, an extra 2 years, an extra 5 years on a 30-year sentence, whatever it is? I don't think so. Yeah. Flip it that way. So all sorts of stuff, broaden it up, let's go.
Yep. Len, what do you think?
I would like to see the process not go through the Department of Justice. I think that would be an important reform. I think prosecutors certainly have an important voice. They should weigh in, but they shouldn't have as much control over the process as they do now.
Okay. Shon, what do you think?
Well, I would, again, overlapping remedies. I agree with what Huma and Len said, but I would love to see Congress bring federal parole back and have a parole board that is somewhat protected from the political system and the ups and downs of what we're seeing now, where we've gotten a little bit of criminal justice reform. And because of the pandemic and other issues, we've seen crime go up. And now all the politicians want to take those reforms away. And so You know, too often in this country, we set criminal justice policy based on the one or two bad anecdotes. And so to the extent that we could create a parole commission that's somewhat protected from the political system in a way that a president is not, and that has no exclusions for categories of offenses, that would be on my wish list.
All right. Mary Ann, what do you think? JaneAnne, I'm sorry.
Well, yeah, I guess I heard Huma say categorical, and I would love to see the Second Step Act that made a lot of these changes retroactive, and I guess I would love to see more counsel for individuals. Let's let the CJA counsel represent people in these cases. Federal defenders represent them. We saw what an amazing job they did on compassionate release. And really, there's no way to really be successful with clemency unless we have counseled petitions. So that would be the reform, I think.
Okay. Now, let me ask all of you, whoever wants to take this question, for the students in our audience, what should we be saying to these students about how they can position themselves to do this work, to do this second chance work?
We have such a wealth of law students. I mean, I have a Twitter account. I mainly use it for silly things because I have to be serious in real life. So I don't want that on social media. But I have the benefit of talking to so many law students who are so passionate, but a little discouraged because they're like, I just don't see a path. Even if I do law review, even if I do all these clinics and these internships, externships, I just don't see a path to really being a meaningful clemency practitioner like I want to be. And the thing is, there's no one real path. There's no, point A to point B with, your name and clemency lawyer under it on the door. Pick something in the field. You hate mandatory minimums, go, work with Pam on that. Do anything you can, write about it anywhere. Pick another cause, medical advocacy for women, especially, for menstruation, for little things like that just fall in the cracks. Pick something. We all have so many interests, and law students are so passionate, so hungry to do the work, to get in the advocacy spaces. Pick anything, go anywhere with it, and chances are something meaningful will come about it, probably in a way that'll surprise you. There's no shortage of ways to help. So the single-minded focus is lovely. It shows determination and spark. Open it up. There's no end to what you can accomplish.
I would just add, I also teach it as an adjunct at DePaul, and I've had students that have helped me in my work and that have a lot to offer, helping with their computer skills, going through electronic discovery. But I think clemency is an area where students can really help, because it's telling a story, as our panelists have described it, telling a story, getting information about the client and putting it in a compelling narrative. So I think it's an area where students can really be helpful to practitioners.
And let me add on to that. My experience during the Clemency Initiative, we got a whole consortium of lawyers doing pro bono work on behalf of petitioners, and it was great. But sometimes, talking about law firms, we'd get like a 400-page filing. And somehow it seemed like the law firm thought the president would sit down and read this 400-page motion. And it's not that hard to do a clemency petition. It's just not that hard. I think law students can really do a good job at it. And it's more important to get something in. Yes, it has to be high quality, but it doesn't have to be something that takes 6 months or 8 months. It doesn't have to be long. It just needs to hit the important points and really humanize the petitioner and show the redemption. So I think law students and non-law students can really take part in clemency petitions. JaneAnne, what do you think?
I would just add that, it's true, get their story in, and that we're so much further along in the way if we can really humanize and deepen the knowledge of who this person is and where they came from and why the pathway to crime worked out the way it did. You can so often see the cascading circumstances and horribleness that led to it, that this person isn't a bad person, just had a lot of really terrible things happen to them that worked out this way. But I would say, make sure that you surround yourself with experts. There are experts available. There are experts on prison issues, experts to help you analyze that disciplinary record, people to help you develop a reentry plan. There are really good ways of thinking about a reentry plan, and the plan that your client has to go live with someone they've been, pen paling with isn't really the best plan. It's not one that's going to give a decision maker comfort. And so there's lots of ways out there to get, expert guidance on making this the best petition it can be. So don't be afraid to ask. People are always happy to help.
Great. Shon, you're teaching students. What do you do with them?
Well, I think my pitch would be the same for law school students as it would be for any practicing lawyer. I'm an academic. My day job is supposed to be writing academic papers. Haven't done as much of that in the last 2 years, in part because I don't think there is any more rewarding work in the law than getting someone who is deserving out of prison early and reuniting those families and seeing that happen. It's a feeling that few people in the law will ever get, and it doesn't require you to have expertise in criminal law. I've seen contracts lawyers who prepared a good clemency petition. And so, my pitch would be, you're going to get to work on a case that could be life-changing for an entire family. And so get involved, whether it's the Compassionate Release Clearinghouse or volunteering, or just send me an email. I will have no problem finding you a case.
And, we have to take head on this issue now with the rise in violent crime, which is mixed, actually. It's more nuanced than, of course, the press reports and the politicians take up. But when we're getting people back into the community who have gone through a whole lot of things and have overcome a whole lot of hurdles and are now mature, responsible individuals, their contribution to the community can reduce crime rather than increase crime. And we should really think about how we address that issue and make sure the judges and the Office of the Pardon Attorney know that there are good reasons, even if there is some rise in violent crime, to let people who have earned it return to the community. One last thing, we've got a couple minutes. I'm going to editorialize for just a moment, if I could, because hearing the last panel, I have tremendous respect for Mark Osler and Rachel Barkal, and I think Len said this too, of taking the pardon attorney's office out of taking the pardon process out of DOJ. And I disagree, but only if certain conditions are met, because I believe the pardon attorney's office can really function effectively in making recommendations for commutation and pardons. But there has to be a change in the delegation of authority. The recommendations of the pardon attorney have to go straight up to the White House, because absolutely there's an inherent conflict with the DAG, the Deputy Attorney General, who's in charge of all the federal prosecutors in the country, who's in charge of all the federal agents in the country, at least the ones in the Department of Justice, and therefore is completely compromised when it comes to decisions on whether a person's sentence that was final at one point should be changed, should be reduced. So I'm not with the idea of a separate commission, because I've seen the Sentencing Commission, and I just don't think it got us very far. It really took us in the other direction. I'm for using the pardon attorney's office, but using it with resources and good lawyers in there, and letting them recommend directly to the president, and then having the prosecutors and the DAG put in their opinions as well, but not having the final word. Let the pardon attorney send the recommendations to the White House. That's my small editorial for today. I think we're running out of time. Any last comments?
Well, I'm just going to say one thing. we often talk about the fact that our clients are serving time with their families, that the families are serving it too. And I think that's so true. And it's really tragic. But, when they get clemency, when our clients get clemency, the families get that clemency as well. The communities see it. It is extraordinary, the symbolic power of that. It's not just one person experiencing it. There's a whole ripple effect of people seeing a face of the law that is, mitigated and kinder, and it helps build connections and address the alienation that we have in our communities. And so clemency, it's very individual, but it has huge ripple effects.
Absolutely. And until we get a second look statute, we got to keep pushing clemency and compassionate release. We do anyway, but especially in the absence of a second look statute. Thank you all so much. This has been a learning experience for me, I hope for our audience, but we're out of time now, so we'll have to say goodbye and thank all the sponsors, the wonderful people who set up this symposium and gave us a chance to express our views and share.